Morning, sir.
Good morning, sir.
And let me also welcome you to a brand new week and possibly the last class for this semester, at least so that you can have the next few days to do your revision and set for your exams. During the last class, we discussed law and ethics, and that is what we are actually concluding with in our first semester lecture series. We hope to answer a few questions, which are: one, how has the general climate in Nigeria affected the rules of professional conduct? Who is that? Somebody is disturbing us. Tunji Lawal. Two, what is the mode by which violation of the rules of professional conduct is punished? Three, we should have an idea of what the rules of professional conduct is about. The rules against advertisement, and whether the conferment of the rank of SAN has actually made for progress of the legal profession or the legal practice as it were. But talking about ethics, I think the first thing we need to emphasize is the character of a lawyer. What should be the character of a lawyer? Essentially, a lawyer's character should be integrity driven. And when we talk about integrity, it is not something you can pick on the shelf. It is not something you can pick on the road. It is not something you can pick just in the middle of your life or the tail end of your life. It has to be part of you. And if it must be part of you, what are those things you need to do for integrity to be part of you? The first thing, in my view, is honesty. In whatever situation you find yourself, you must be truthful. And the general perception all over the world, not necessarily in Nigeria, is that lawyers are liars. Of course, this is not so. Of course, this is not expected to be so. Because as a lawyer, you are not expected to ask your clients to tell lies. As a lawyer, you yourself are not expected to tell lies. But there are circumstances which present us as liars to the public, and that is the law which we deal with, the law that guides our operations. Let me give you an example. When we talk about stealing in the normal circumstance, either theft or stealing, depending on which side of Nigeria you belong, what the prosecution is expected to establish is that, one, the property that was allegedly stolen belongs to somebody. Two, that the person alleged has taken the property without the permission of the owner. Three, that the person alleged has actually taken the property with a view to permanently denying the owner of the ownership of the property. So that's to an average mind, to an ordinary eye, is simple enough. However, by the time we go into life issues, I left my biro on the table. They picked it with a view to deny me of the use of the biro permanently. B saw A when he picked the biro. And still, in court, the court says, I have not been able to establish that A actually stole my biro because I was unable to establish that B saw A when he picked the biro. To B, who saw A picked the biro, that will be, he won't be in a position to actually come to terms with the idea that I've not been able to establish that he actually stole my biro. But as a lawyer, you are not expected to ask your client, hey, who stole the biro, to tell the court that I did not steal the biro. It is the duty of the prosecution to establish that A actually stole the biro. If for any reason prosecution is unable to now establish that A stole the biro, then it will be seen as if the lawyer is telling lies. I hope we are together.
Yes, sir.
Yes, sir.
Fine. So the point we are making is that a lawyer is less expected to tell his or her client to tell lies. However, he or she has a responsibility to allow the client to maintain his or her innocence. So usually there's that quote and unquote a conflict. Yes, your client must not tell lies. Yes, you must not tell your client to tell lies. Yes, as a lawyer, you are supposed to be integrity driven. You are supposed to be honest, but yet you are asking your client not to tell the court that I stole. You are also asking him not to tell the court I did not steal. So where does this leave us in the ethical prosecution of the life of a lawyer? That's a question that we need to navigate. Can somebody, I hope you got the point I'm making.
Yes, sir.
So how do we strike the balance to ensure that the ethical values, especially the character of a lawyer, especially the idea of a lawyer must be integrity driven, is not compromised?
Sir, in my
Yes.
opinion,
Alima.
I feel, yes, sir. Even though a lawyer is not expected to outrightly just refuse any case, I feel a lawyer is allowed to just maybe refer a client to another person if what he has brought goes against his conscience, as in line with the code of conduct and even his own personal concerns. So if a client has outrightly told his lawyer that I actually stole this thing, but I want you to help me win the case, the lawyer, if he feels it goes against his conscience, can, in my opinion, refer him to another lawyer he feels can take it, or accept the case but refuse to lie outrightly to the court by just telling him to not plead not guilty. Sir, do you understand me, sir?
Yes, I do. But
So
your prescription, if he now gets to another lawyer who will be ready to sell his or her conscience, it doesn't really matter. But we are looking at the totality of the profession.
on
and
that,
not
I'm saying,
and not A or B as individual lawyers. So
yes,
sorry, the point that you have made, that I've understood, that you have made, is that, oh, if a client comes to you and tell you I have stolen, but I want you to help me to defend me, because that's the only duty that you have as a lawyer. And defense one should not take you to the level of telling the court lies, because first and foremost, you are a minister in the temple of justice. So the point, my concern is your recommendation that, oh, if he wants to go against his conscience, if he does not want to go against his conscience, the client should go elsewhere. I am saying going elsewhere means that that other lawyer is ready to compromise his or her own conscience. I hope, Alima, I hope you got the point I'm making.
yes, I understand your
Okay.
point.
Okay.
My recommendation for the other lawyer would be to not encourage his client who he knows is guilty to plead not guilty. He can just tell him to maintain his silence and see if the prosecution can prove it.
Now, let's still go further. Is pleading guilty, or pleading not guilty, lying?
Yes, in my opinion.
That's a good one. In your own submission, yes, let's hear other people's views. Except to say that if you plead not guilty, it is not a lie. The only thing you are doing is to ask the prosecution to establish your guilt. Not that you are not. You are asking us what the question was. You came late, and that's the price for coming late.
It was network, sir. It was network problem.
Yeah, sorry.
Same here, sir. We don't know the topic of discussion.
We are discussing law and ethics, and we started with the idea of the character of a lawyer, and that the character of a lawyer should be integrity driven. Now, talking about integrity, I said the natural or the general perception of the society is that lawyers are liars, but that is not the situation. We painted the scenario with regards to theft or stealing, and the need for you to defend your client who you know has stolen, but without having to compromise your integrity. So how do you strike the balance between doing your duty as a lawyer and maintaining your integrity as a lawyer? And Alima came up with his own, our own perception that, well, if somebody had told you as a lawyer that he or she has stolen, your conscience should not ask or advise him or her to plead not guilty. And my position is that pleading not guilty is not telling lies. Pleading not guilty by our rules is just to put the prosecution on to do his or her job, because prosecution is expected to establish the guilt And if you now say, I am not guilty, that is not to say, because even in capital offenses, when you even plead guilty, not guilty will be recorded for you. For instance, murder, armed robbery. If you come to court and as an accused person, and the court says, are you guilty or not guilty? If you say not guilty for capital offenses, they will write, I mean, if you say guilty, they will write not guilty for you, because the prosecution has a duty to prove the case. So I hope you get the point you are making. So can somebody else attempt to?
Thank you very much, sir.
Hello?
Can you
Who
hear
is
me, sir?
this?
This is Sean.
Yes, who is this?
Sean, sir.
Okay.
In my own opinion, I want to believe that a lawyer in that kind of situation will not be compromising on his integrity by not advising such clients to plead guilty. And this is because the rules of professional conduct is very clear as to representation in court. And what the lawyer is simply doing in that regard is doing his duties. And as lawyers, we are not meant to be selective of the jobs we take, in as much as it will aid the administration of justice.
Yes. Yes, that's another view. Yes, any other person to give a shot at it?
Yes, thank you very much, sir.
Yes, Tunji Lawal.
Yes, I think the position is just as Shomokwe has just said it now. But when we are talking about integrity, I don't know in which context we are talking about it. So to me, where a lawyer finds himself in such a situation, if he wants to maintain his integrity, he can just opt out of that particular job by not doing it. Because if a lawyer keeps on saying that it is because it is my duty, I will keep on assisting offenders who I know they are real offenders. It is as though the lawyer is also contributing, I don't know, his own quota, quote and unquote, to the various atrocities that could be happening in the society. Because some lawyers have taken it as their habit to be rescuing offenders, and these offenders themselves, they now know these lawyers that even if you commit the highest offense in this country that we have, if you get this kind of lawyers, you'll be able to find your way through. So in that sense, I want to believe that if the lawyer is to maintain his integrity, just opt out of that particular job. You don't need to expose the offender. Just make sure that you want to keep your own conscience clean and leave that particular job. So that's just my view, sir.
But there's a problem. If we believe that our laws are not supposed to be followed to the letters, our jurisprudence is to ensure that an accused person is given the benefit of the doubt. An accused is, even at the time he's saying I did it, is presumed innocent by the law. And a lawyer is not to judge. Let me give you a few lifetime examples. One is still ongoing. It has not been concluded. We were all witnesses to the offer robbery in a few years back, where a number of people died. And five individuals were accused to have been part of the armed robbers. And at the end of the day, so far, the only thing that has linked them to the robbery was the investigation of the police to the effect that an armed robbery took place in Offa that day. It has also been established how these things happen. But at the time the prosecution was to start, there was nothing like ammunition. There was no evidence from any family member that died. There was no evidence from even the police station that was allegedly cannibalized. So if prosecution had gone into the matter without taking into consideration all these major issues, and at the end of the day, the court has nothing to convict them with, can we now say the lawyer that defended them had compromised his or her integrity in the light of the failure of the prosecution to bring those major things before the court? So for those of us that believe, if you defend an accused person, you have compromised your integrity, because that's what I understand Tunji Lawal and Alima to be saying. Whereas the rules of professional conduct that emphasizes integrity has given a lawyer a duty not to compromise or divulge the information that came to him or her as a result of the brief he or she took from his or her client. So the point I'm making is that if our rules are clear that an offender is innocent, should the lawyer, in maintaining integrity, now decide or refuse to take a case because of that particular, will that compromise his or our integrity? That's the point I'm actually hammering at.
All right, sir.
Yes.
Yes. Thank you very much, sir. Yes.
Yeah.
So I want to believe, sir, that it depends where, or let me say, to what extent does the lawyer wants to protect his integrity. If the lawyer wants to protect his integrity to the extent of the rules of professional conduct, then so be it. That means that if he goes by the rule, particularly by not divulging the confidential information that the accused person has given to him, then it means he's following the rules with regards to his integrity. But where he wants to maintain his integrity beyond the letters of the rules of conduct, beyond the letters of the law, and he wants to maintain it as a human being, then he knows what to do. Because I want to believe that our adversarial system of jurisprudence that we are using itself allows for integrity to be, I don't know, because even if a judge sees an accused person committing an offense like this, the judge cannot, because of that, go into the arena and says he wants to convict the accused person until and unless the prosecution is able to prove his case, their case beyond reasonable doubt. So that kind of thing, in fact, to me, the integrity of such a particular judge should be in question. Because in as much as you see something that is being done like this, and your hands are tied to say that this thing is actually done when they cannot prove it before you. So that is just my own opinion. If he wants to maintain his integrity in line with what the rules of professional conduct have laid down, then it means maintain his integrity to such an extent. But where he wants to maintain his integrity beyond the letters of the law and as a human being, as it ought to be, then when you know that an accused person has actually committed an offense, what a person that wants to maintain his integrity should do is to just leave such a case, because he has found out that the accused person has actually committed the offense. That's just my submission, sir.
I guess if we go by this your submission, then there won't be need for any lawyer in the society.
Hello, sir.
So let's clear with Tuji Lawal. I have a question. Tuji Lawal.
Yes, sir. I'm with you, sir.
I said it means that if you go by this your prescription, there won't be any lawyer in the society.
Yes, maybe, but I think, in my own opinion, sir, justice will actually be maintained, because the fact that we have many lawyers now does not mean that justice is being maintained in our society. We just have lawyers, but there is absence of justice. But if such a situation, or if such an instrument or a platform is created whereby, can you hear me, sir?
I'm with you.
Yes, if such a platform is created whereby lawyers, because of their integrity, do not take such cases, then it means that justice could be, in my own opinion, justice could be maintained more than what is obtainable today.
So anyway, I guess your own idea of justice is just justice to the society, as it were. Whereas we have said justice is a three-way traffic. Two, do you think, or do you still believe in the innocence of an accused person as a concept?
Very well, sir. Very well.
Okay. So can we have other people's view so that it doesn't?
Yes, in this way, sir, if a person has not committed an offense, I don't think such a person can actually say he has committed an offense. So in that wise, there is no way our system, the system of our education of from our police officers is, I don't know, they don't, in most cases they don't carry out investigations.
I do not
Yes.
think that integrity of is going to be called into question by his refusal to aid the prosecution's case. Because if we're talking about the fact that, okay, the lawyer knows that this person has committed a crime and is not saying anything, I don't think the integrity of the lawyer will called into question in that aspect, because according to our ethics, a lawyer need not assist a prosecution's case. So even with your client is supposed to remain between you. And as long as the court is not going to put you on the spot and ask you whether or not your client has actually committed the crime, I don't think there will be a point in which you have to pick between your integrity and your client's interest. As long as I feel like the only line when it comes to integrity will be when you are then fabricating evidence to absolve your client of guilt. But as long as all you do is stand by and watch the prosecution prove its case, I don't think your integrity is supposed to be called into question. And then, as a matter of personal integrity will always be subjective. If every lawyer is going to go based on personal integrity to decide whether or not to take a case, then most people are going to be left without defense, because everyone using their own personal threshold will probably feel like, okay, this case is going to affect my convictions and all, and then reject the case. So I believe that what our legal ethic or our ethics in Nigeria for lawyers is saying is that you need not aid the prosecution in proving its case
you need not fabricate evidence. Let the prosecution do its job and then do your own job by your client. So I think that has created a balance between your personal ethics and your client's interest.
Fine. Do we have any contrary view?
Not
At least you
contrary,
have,
sir, but just an addition, sir, to what Linda has just said.
Yes.
Looking at the whole essence of jurisprudence as given by Jeremy Bentham, or the way he defined jurisprudence, we can see that this is just being methodologically ignorant of the obvious and trying to ensure that we make research into it to actually ensure, test it, whether or not it is actually true or not. So I do not believe that it negates the lawyer's integrity in any way, because we are only following the rules and the letters of the law.
Fine. I think that will then take us to how the general climate of the Nigerian people has affected the rules of professional conduct. We have just discussed the integrity of the lawyer vis-a-vis the rules of professional conduct, vis-a-vis defense of his or her client's interest. Now, I have said that the general perception is that lawyers are liars. How one, as the general attitude of Nigerians affected the Nigerian lawyers. What do I mean? An average Nigerian, with due respect to all of us, is lacking in integrity, majority. And this is obvious from the way we conduct ourselves generally. And that has actually affected the way lawyers conduct their business in Nigeria. For example, in developed economies, America, UK, Canada, and all this stuff, if a lawyer takes on a case and for any reason, there is now a conflict between his client and the society, the lawyer in America is likely to pitch his or her tent with the society. Whereas in Nigeria, an average lawyer, where there's a conflict between his client and that of the society, the average Nigerian lawyer will pitch his or her tent with his client. And let's look at what happened recently. Secondus, the chairman of PDP, was to be removed. A lawyer went to court in Rivers State, got an ex parte order restraining somebody that had acted, that had been in office for almost 3-4 years. Didn't stop at that. Another lawyer went to another court in ZKB also, reversed the order. Yet a third lawyer went to another court in is it Cross River or Akwa Ibom, got another injunction restraining. So the point we are making is that this is essentially about the attitude of the Nigerian, which has affected the Nigerian lawyer, that we won't be in a position to know that, oh, there was an order in Rivers State restraining this person. There is no reason if I want to vacate that order. So even if Secondus had come to you that he wanted an order not to restrain. The natural, talking about integrity without the Nigerian climate should be, oh, let us go back to the Port Harcourt court to vacate the order, and not that we should go to another court in another state to get a contrary position. So the point we are making is that something about us in Nigeria that has affected the practice of law in such a way that we do not now practice law the way it should be practiced? Does anybody want to give it a shot?
Yes, sir.
Yeah.
There is no way, I want to believe that there's no way that a mentality that is operating within your enclave would not affect your professional conduct. In as much as we want to believe that that should not be so, it is happening. And I want to believe that the lawyers in the advanced countries that you cited, they were acting that way because of the society they found themselves. So I want to believe is an issue of mentality which we cannot totally eradicate from our system.
Thank you. Yes. Any other view? Any other view?
I would like to add
Samia.
to what you just said, sir.
Okay.
Yes, sir. Yes, sir. One minute,
Yes,
sir.
I'm with you.
Yes, sir. To my own understanding, I believe the society mindset.
What about the society?
Hello,
Find out.
sir.
I'm with you. I'm
Yes.
hearing you.
Yes, sir. It shapes the mindset. So I believe it's not possible to remove the way we think and the way we operate in the society, in the way we go about our laws. Just like one issue or the other, because they have the issue of racism that affects people that look like me over there. Almost every day, a Black person is becoming an hashtag and they don't have a say over their lives. So, in this kind of scenario, we have I can say that the experiences of the bodies, it depends. Like the experiences each person can say going through depends on the bodies they find themselves. But when we come to Nigeria here, that we all look alike and we all have the same features and all, I believe it has to do with the mentality which Shomoko just mentioned, and it's something we can't totally remove. So,
Thank you.
Yes, sir.
Yes. Olatoyinbo.
Thank you very much, sir. I don't think it is possible to eradicate it totally in the society. Just as Shomope has said, that is in our mindset. And even though, sir, if there is total eradication of sin among all lawyers, what of the judges?
Yes.
So my opinion is there should be stringent punishments. There should be law in place, and a stringent punishment should be attached to it, that whoever contravene these ethics is going to be punished or is going to face the wrath of the Lord. I think that would be the solution. Otherwise, that is how it will continue.
Yeah. So essentially, what I had us saying is that we cannot be an island unto ourselves as lawyers in the Nigerian society. But I think the area I want to emphasize, and which I think should be something we take into the society, is that lawyers are expected to be honorable men. The legal profession is a noble profession, and part of the training we are supposed to have is to reform the society. And therefore, whilst it is understood that the Nigerian society is quote and unquote bad, debased, dirty, still we must be in a position as lawyers to live above board and not just to say we are lawyers in Nigeria. And therefore, because what strikes me is that a lawyer that is a lawyer in Nigeria who believes that, oh, anything goes, who will think of, oh, how can I, if I can't win this case, how can I delay it? Who believes that, oh, I can put some legal technicalities in place to ensure that justice is not attained. Will, if such a person leaves Nigeria and decides to live in Canada or US or UK, it will still be a different person. But that does not remove the fact that he's a Nigerian. While the climate is important, it is important for us to emphasize that as lawyers, we are not supposed to join the Joneses. We are supposed to be reformers in the societies. We are supposed to be social engineers. We are supposed to find a way to use our profession to cleanse the society as it were. Now, do we have questions?
Just a remark, sir.
Okay,
Yes,
Roland,
questions.
let me listen to Roland's remark, then question by Tunji Lawal.
Yes, sir. My remark is just to the last thing you said, the emphasis you just made about lawyers becoming social engineers and living above the system they found themselves or trying to make things right. But unfortunately, my reaction to that is, so long as we live in this climate we are, this Nigeria of today, where poverty and hunger is ravaging almost every aspect of human existence, it's just a consequential outcome of the society. I'm sure if you check these lawyers and the judges that released these expertise and these motions that were flying up and down, they must have been paid heavily to be able to achieve that, to get that. They must have been paid heavily. And so it's also part of the problem. I mean, for me, it's like a chain. The Western world you compared with have gone far above us. They will take patriotism, they will prefer to protect their institutions and systems over and above their lives at times. But here we don't seem to be at that level at all. That's just more like a remark to your information.
Thank you. Tunji Lawal.
Yes, sir. So this question basically is being directed. I want to direct this question to Linda and Shomopi, and it's with regard to the first the character of a lawyer, particularly when we are talking about the integrity vis-a-vis the rules of conduct. So, and the question is, just like you have you just submitted on the Nigerian climate aspect, that lawyers we are to be social reformers. So I want to ask them, for example, where a client divulges to you that he has committed an offense, and probably because of the Nigerian situation, the prosecution is not able to prove their case beyond doubt, and you're able to get the offender, the accused person, out. So I want to ask them, can they confidently say that they are upholding justice? Can they confidently say it, that they are upholding justice by doing that? And can we say that justice in that particular case has been done? That's just the question.
Thank you very much.
Sir. Good afternoon, sir.
Yes.
So maybe we
My
should have
name
an
is
attention.
sir. Good morning, sir.
Yes, assist.
Yes, sir. My name is Isaac Aziz. Sir,
Yes, go
that
ahead.
question. Okay, that question is very simple. They can like they are not in any other duty to divulge that information because the law has made it to be that whatever your client tells you should not be divulged to any persons. But of course, it has when the lawyer can be compelled to divulge whatever his client has told him. But in that circumstances, the law has made it to be that you should not divulge. And justice in our courts, in Nigerian courts, are justice that are obtained, gotten by following the law and nothing more. It is not by emotion, it is not by sentiment, it is not by morality, it is by the law. It is what the law says it is justice that is justice. The law says that you should not divulge any information that has been gotten that has been told by the client. So you are under no duty to say that. And integrity cannot come into place because the law has said that you should not do that. In legal profession, we have ethics, and ethics has especially stated that you should not divulge this information. So even by following that ethics, you are also maintaining your integrity in the legal profession. That's my response, sir.
Thank you. I think we need to appreciate the position of law as well as the position of our rules of professional conduct. And we don't have to be apologetic about it in benchmarking the question of justice in the society. The rules have provided for confidentiality between a client and his counsel. The question we need to ask ourselves is, why should there be this rule of confidentiality? This is because at the end of the day, the ultimate decider of a case is not the counsel. The ultimate decider of a case is the court. And if the law at the same time, as defense counsel, you can also not be too forward in defending the client or compromising the interest of your client. When you are not supposed to compromise the interest of your client, you are supposed to defend his interest. And the defense means keep quiet. Let them bring everything that you have done to you. And morality, we have discussed that extensively. Whether you are an harmonist or a person that believes that there is society decides how they want to be ruled, and they can only be ruled by law. So if the law has prescribed, and I find it are you guys hearing me?
Yes, sir.
Yes, sir.
Because
Yes,
I can see somebody complaining that the sound is not good.
We can hear you, sir.
Are you, Samia?
Yes, sir.
Are you hearing me now?
Yes, I can, sir.
Okay, because I saw that you are complaining that you are not hearing me. So the point I'm making is that if we go to other societies that is even different from the Nigerian society, that is the Islamic society. Zina, you need 4 witnesses who saw them in the act to be able to. So essentially, not eventually getting witnesses to establish that a man or a woman has committed zina does not mean the person had not actually committed zina. But in the eyes of the law, zina has not been committed. Yes, we can, from the spiritual realm, believe that at the end of the day, you will have to pay for it in the hereafter. Fine. The same way, in the ultimate justice disposition, whoever is a thief and has not been able to be convicted will pay for it in the hereafter. But within the confines of the society we are, because if we do not have rules, if we do not have laws, if we do not have regulations, the society will be for the nastiest and the survivor will be for the fittest. And that is not the kind of society we want to actually run. And that is why it is said that it is better for 99 people that have committed offense to escape justice than for an innocent person to be unjustly punished. So the society has provided for a buffer zone for punishment of crime, extermination of crime in the society. And with that, we should not have this guilty conscience. Oh, I am defending an accused person who has told me, who has confessed to me that he committed the offense. That is not your duty as a lawyer. Your duty is to defend him or her, but your duty is not to tell lies that he or she did not commit the offense. Your duty is to ensure that the prosecution must prove that he or she committed the offense. And he has a duty to just keep quiet. So let's then move on. The question, one of the questions that we have asked is the rules of professional conduct today proscribes advertisements by.
Excuse me, sir. I have a
You say?
question for you.
You
Excuse
say
me,
what?
sir. I have a question for
Okay,
you.
go ahead. Go ahead.
Yeah, so you
Statement.
say that as a defense counsel, your duty is to keep quiet while the prosecution
No, the
proves your
client,
client,
the accused person is to keep quiet. The
the
accused person.
person.
Yes, yes.
Okay. So
What I'm
he's
saying is
also
that the defense counsel, one, must not ask his our client to tell lies. Two, he can now ask questions under cross-examination to establish what the law has said. For instance, sorry, I will still listen to your question, Catherine. For instance, if the prosecution comes to court, you should be able to ask questions to establish those ingredients of the offense, to show whether what his client has done is or falls within the ingredients of the offense.
So my question now is this. After the prosecution has proved sufficiently the guilt of the accused person, if the defense is expected to disprove that proof, right? So can we say that defense is not what's the word now? compromising their integrity while trying to disprove the truth?
No. I have had opportunity to defend people accused of one crime or the other. There was one that was alleged for ritual purposes to have killed somebody. And in my interaction with the client, it was obvious that he actually committed the offense. And I mean, did what they alleged he did. And all we did was try to establish the position as far as the law has given us opportunity to establish. At the end of the day, the man was convicted. That does not mean that I didn't do my duty as his lawyer, because I've not told lies, and eventually he is convicted. And it's also possible that in the course of the prosecution, the witnesses may not even be available again. It is also possible that in the course of trying to establish or over-establish the prosecution, we miss some steps. And if you go back to the position of the law, that it is better for 99 accused persons to go scot-free than to punish an innocent soul. Because these things that we do, for instance, a person that is insane commits an offense. At the point of the commission of the offense, he was actually insane. He should not be given opportunity to be defended. And all the defense lawyer need to do is to ask, supposing in the course of this, are you aware that this man has a mental problem? Oh, yes, I am aware that he actually left the hospital that day to commit the offense. Of course, the court will discharge and acquit him, and has that he be taken to a hospital for treatment. I hope you get the point you are making. So the law that has provided these safety valves is more interested in the society than the individuals. And protecting the society is far more greater than the individuals. Any other question before we move to something else? Hello? Hello?
No question, shall we?
We are with you, sir.
Yes, sir, we can hear
Okay.
you.
Then
Loud
the
and
question now is, do we or should we be advertising in 21st century Nigeria as a legal practitioner? That's the question for us.
What's the question you asked us?
Question again.
Question again, please.
we didn't hear the question. That's the point of.
The question, I believe, was that okay. Looking at the rules of
Believe I
criminal,
you had.
can you hear me?
Yes.
Yes, I'm to bring the question again. Yes, that in the light of rules of
Please,
profession,
can anyone help with the rationale that supports that law? What is the reason why it is the rule that legal practitioners should not be allowed to advertise? Can anyone help?
Do I get? I didn't follow the last speaker.
Yes, we want to hear the question again, sir.
I said in 21st century, can we still stick to the rules of professional conduct that there should not be advertisement for lawyers. And let me just go a bit further. In today's world, lawyers are on all sorts of platforms, LinkedIn, Instagram, and all the research gates, academia, and all the stuff. And lawyers are practically advertising, as it were. But our rules of professional conduct says you cannot. So the question is, one, should these rules still be maintained? Two, can we say the way people are, quote and unquote, circumventing the rule is right?
I believe we must first get the rationale behind the rule itself. Now, the rationale behind the rule is that lawyers' advertising may be quite misleading. And if a lawyer has advertised, it also means that he possibly will want to get the money for advertisement back from potential clients, which will ordinarily be not. Can you hear me, please? Can everybody? I think he has muted his mic.
Rashid, go on. We can hear you, but the thing is breaking somehow.
Okay, so what I was trying to say was trying to interrogate the rationale behind this rule. This rule was establishted in the rules of professional conduct so as to ensure that there is no inappropriate fee hike.
What I understood Shomakwe to have said was that trying to get the rationale behind the rule in the first place. This rule was made almost 10 decades ago, because the kind of practice, one, the rationale, in my view, is to ensure that we avoid champathy. That's essentially what the rule.
Sir, please come again.
I said the rule essentially was put in place so that lawyers does not be seen to be chasing briefs. However, in today's world, especially in societies where advert is actually encouraged, you will see lawyers that will come up on television to say, I am an expert in immigration law. You will see lawyers that will say, I'm an expert in tax law. You will see lawyers that will say, I'm an expert in this or an expert in that. And if you go back to what we even do in Nigeria today, you will see lawyers go on television and he will be described as a foremost constitutional lawyer. Is that not an advertisement? People will go on LinkedIn and start raising issues, identifying issues or areas of law that he will be exhibiting a level of expertise. Would that not be an advertisement? Can we in 21st century still say, oh, because we don't want lawyers to be seen to be chasing briefs, then advert should be discouraged? Yes.
Okay, so I feel like that rule about adverts in this age, it's not for the benefit of lawyers, because it was made at the time where
It's what?
it's not really for the benefit of the lawyers.
Okay.
Because as at the time when the rule was made, I would like to say there were as much lawyers as there are now. Now, before somebody can get a brief, even as a young lawyer, it's going to take years or a lot of help and all. So if we are not allowed to advertise, how do you expect us to get clients?
Well, I believe that the society is dynamic, and these are issues that we should ponder on and go back to why it was, and what is the situation now, and how can we continue to still stick to our guns. I want you to read the rules of professional conduct for legal practitioners. I think that there's a 2017 rules now. Please look at them critically and identify areas that you think you could make provision for improvement, as it were. The next question that we need to ask ourselves, which will be the area where we'll be closing the discussion, is the rank of senior advocate of Nigeria was designed to create goals, aspirations for lawyers, so that you can aspire to, oh, I want to be this in my profession. I want to be that in my profession. How has conferment of the rank enhanced the practice of law in Nigeria? So should the rank be continued? Should it be exterminated from our practice in Nigeria, so that we have a level playing field? That's the argument of some people, while others believe, no, it has enhanced the status, because if you have goals, if you have aspiration, then it will it will serve as a moderating influence on the way you behave. But it has also been argued that in spite of that, we have had senior advocates of Nigeria even misbehaving worse than the people in the outer bar. So what's our view? Yes,
should continue to be like it is. However,
I'm not hearing you. I'm not hearing you.
Can you hear me now, sir?
Yes.
Thank you very much. I said it is my view that the rank of senior advocate of Nigeria, as it is being conferred now, should continue. However, my concern is the fact that it is becoming, I don't know the appropriate word to use now, but I think it is becoming withered down. Like its credence is becoming withered down because of the fact that a lot of people are now getting it. Unlike before, that the conditions are so stringent that you can hardly get it. Because if it is being given out the way it is being given out now, it will in no time lose its relevance. So I believe the conditions that are attached to it should be more stringent than they are now, because to achieve that kind of rank, you should you should be phenomenal as an advocate. So I think the conditions are not adequate anymore, or are being weighted down in some ways, sir.
But ironically, the conditions now are far more stringent than it was before now. The conditions now are really, really stringent. And the problem, I think, is not with the conditions. The problem, I think, is with the conferring authority, and not one believing that we should make it a federal character thing. We need to have people from the north, we need to have people from the east, we need to have people from the west, and we have zonalized it, as it were. That's one major thing that I think is bedeviling the thing. Two, I also believe that because of the way that the legal profession is structured, such that everything in Nigeria now is senior advocate of Nigeria, senior advocate of Nigeria, senior advocate of Nigeria. It's created a rat race that people are even bending rules to be able to get there. Three, I also believe that water tends to find its own level. Even if the whole of Nigerian lawyers are made senior advocates, people that will excel will excel. The ones that will, because in Nigeria today, you can imagine the number of lawyers that we have. Plus or minus, we have less than 1,000 senior advocates of Nigeria in Nigeria today, dead or alive. And in spite of that, we believe that the number is increasing. For me, the conditions should be as stringent or as relaxed as we may want. But what I think is important is emphasis on who becomes in terms of integrity. I also believe that the rank has actually enhanced the practice of law in Nigeria, one way or the other. But the duties imposed on senior advocates of Nigeria should be, there must be a way to check whether these duties are, for instance, there's a minimum number of lawyers that should be in your office before you become, at least from the practice side. From the academic side, there's nothing like that. And ironically, people take the silk as academics and then go into practice, because when you go to court, nobody knows whether you are an academic SAN or a practice SAN. And because of the volume of work that is attached to the rank now, virtually everywhere you need a senior advocate. We need a senior, and that is actually the problem. Whoever takes the silk should have the necessary there must be necessary character check to know that those that are actually conferred with the rank are well deserving of the rank. Do we have questions? Comments?
Good morning, sir.
Yes.
Sir, please, I didn't get the first point you made about zonal, like zone, when it had to do with conferment of senior advocate of Nigeria.
Yes, I said now, one of the problems is that they now make it as if, there must be, if you want to appoint 10, for instance, it must spread. That is, you cannot have the 10 all from the southwest. There must be from south-south, from southeast, from from northwest, from north central. That's the problem that I think is part of the issues that are being raised to now fault such that if, for instance, you have somebody having because anybody that is shortlisted must have met the minimum standard. So in now choosing, we now want to choose 20. You now say, there's only one person from Northwest. It means we have to pick that person, irrespective of the fact that one is a first timer and somebody has been applying for the past 10 years from some other regions. I hope you got the point I'm making.
Yes, sir.
Yes, sir. Thank you, sir.
Any other question?
Yes, sir. By way of comment, sir.
Okay.
Yes, sir. I think the SILK, the rank of senior advocates of Nigeria, is something that occupying it is very, very laudable and encouraging. But just like Shomakwe initially mentioned, it is fast becoming losing its credence if you continue with the trend of having an influx of persons being conferred the rank year in, year out. I mean, for instance, in the UK, it takes a whole lot of effort and process before a person moves into the king or queen's
council.
King or queen's council. So
we are not hearing you again, no. Olalawa, we are not hearing you again, no. Well, I'm not sure we are hearing this guy again. So any other question, please? Well, if there is no other question, I think we need to leave ourselves at this point and wish you a very successful revision, and also wish you all the very best in your exams. Meet you in the second semester, God willing.
Thank you.
Thank you.
Thank you very
Thank you very much, sir.
Thank you, sir.
Prof,
Thank you, sir.
do you have comments?
No, I'm okay, sir.
You're always okay.
Thank you, sir. Bye-bye,
Okay,
sir.
have a wonderful week ahead.
Thank you,
You
sir.
too, sir.
Thank you, sir.
Thank you, sir.
Bye-bye.
Thank you, sir.
Bye, sir.
Bye.
Love you, sir.
Thank you, sir.